Buchheit, you're one of those wonderful lawyers from New York. You've made a lecture tonight and you've been telling us about the future of sovereign debt restructuring. Now you come up with the solution saying Greece absolutely needs a new restructuring of its sovereign debt. Why is that?
Greece's debt to gross domestic product ratio is north of 175%, 3 times what most economists would say is healthy. Most of that debt now, though, is not owed to commercial creditors, to bondholders. Most of it is owed to official sector institutions, the European Union and the IMF. Greece's ability to service that debt on normal terms is still severely constrained. The austerity has bitten very deeply. The result must be, I think, that there is some form of rearrangement of those obligations, not, I suspect, a write-off in the sense of a reduction, but rather a deferment and a reduction perhaps of the interest rate.
But we already have this. We have 50 years maturity, and we also have very low interest rates.
Some of it has happened, yes, but not all of it. There are still portions of that debt that would be subject to some form of further adjustment.
Now, many of the creditors are from Germany, and also the German government is involved, and the ECB, and by this mechanism also the Deutsche Bundesbank. So basically it turns out what you say to the Germans, forget about your money.
No. That's where the write-off issue comes in. I don't think you forget about your money. But what you do say is that the hope that prevailed at the time the crisis broke in 2010, which was that Greece and the other afflicted countries would grow out of their debt crisis. We all know that growth in Europe has been anemic in this period and remains so. So it is a question, I think, of continuing during the period when fiscal adjustment and other adjustments hopefully will return competitiveness and growth.
Can't the Paris Club do this? Can't the Paris Club just say, right, we're going to write off like 50 or 90% of the Greek debt?
Conceivably, if the members of the Paris Club, who are the 19 OECD countries who form the club, were to agree, conceivably, yes. Politically, I think it is a remote possibility.
You've said also that there is a new judgment from a judge in New York saying that Argentina has to pay holdout creditors. Now that's, what you say is that also afflicts Europe. Why is that? That sounds like, some sort of animal in China is doing something and it has an effect somewhere in Europe.
Yeah, the provision that the judge looked to in the underlying bonds as the basis for his judgment is one that is ubiquitous in sovereign bonds. It promises that debts will rank equally with each other. Conceivably, you could have judges in other countries interpreting that provision the way this New York judge has, and in effect saying that if you wish to pay creditors who accept a debt restructuring, you must ratably pay those who do not. And that would cause a considerable difficulty in getting a debt restructuring done.
But you also say the judge was wrong.
My view is that there was no precedent for interpreting the clause in question in this way. If you look back at the literature about the clause, which, as I say, is ubiquitous, and the practice over the last 35 years, equally ranking debts, such as a debt owed to the International Monetary Fund, has always been paid in sovereign debt workouts, even when commercial banks, bondholders, government, Paris Club creditors have been restructured. In 35 years of doing this, no one has ever suggested that that situation violated this contractual provision. So I think it is without precedent that I'm aware of.
And what you say is that now we hinge on some new cases, because this case in New York is sort of closed and it's not going to be changed. What do you expect?
Well, remember the international bonds are issued mostly under either New York law or English law. The English judiciary has not spoken on this issue, and the English lawyers with whom I have spoken believe that an English judge would not interpret the clause in the same way. So it may wind up being confined to New York law bonds, sovereign bonds, but I suspect what will happen over time, there'll be additional cases in which plaintiffs, people who bring the lawsuits, make the argument, and judges at that point will look back on the precedent and say, is it confined to the facts of Argentina, or is it more general? That's the way the common law system would work.
Okay, so in the end, it also would be possible that people don't issue bonds under New York law, but go to London, and for a long time, New York is not going to be a financial place.
Well, New York will be a financial place, but it's interesting what you say. If the New York legislature felt that this decision really was driving issuers out of New York, then they might decide that they would change the law. But I think it's too early to know how sovereigns are going to view this. Are they going to see this as a sufficient threat that they would begin to issue a bond that might have been issued under New York law? You can issue it just as easily under English law. So I think it's too early to know exactly what's going to happen.
Thank you very much.
Thank you.